Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast. This edition we look at Spendthrift trusts for addicts, children that have financial problems and problem children. A Spendthrift trust is one of the best options when estate planning for addicts. There are several forms of this trust a parent can consider. Each has its pros and cons. At its most basic, the Spendthrift trust enables a parent to put spending authority in the hands of a trustee or a trusted person who will control the reckless spending of the child. This can prevent them from wasting funds and can prevent them from using funds to purchase drugs. Spendthrift clauses in trusts also are valuable because a parent can use them to provide necessary funds such as child support, alimony, food, shelter to the beneficiary without allowing them to spend anything else. This enables a parent to offer support even after the parent is deceased. Finally, spendthrift clauses typically protect the funds in the estate from creditors. So long as the funds are in the trust, creditors cannot reach them. This is ideal in instances where the child may have to declare bankruptcy due to poor financial decisions while under the influence of drugs or alcohol, has a large amount of debts, or is likely to accrue a large amount of debt. However, once the funds are taken out of the trust, they can be garnished by creditors. In some cases, a parent may be able to set up a discretionary spendthrift supplementary needs trust, which enables the child to qualify for needs-based governmental benefits such as SSI, Medicaid, housing, SNAP, etc., while offering the other benefits of the trust. The best way to set up is to create a testamentary discretionary trust with a spendthrift clause, which will come into effect after a parent is deceased. Then the funds are moved into the trust and spending is controlled by the trustee for the benefit of the child, who is the beneficiary. So, we talk about risk avoidance. If the elderly parents transfers assets to the children rather than putting it into the trust, certain risks must be anticipated. These risks can be avoided if the assets are put into a trust. The risks of an outright transfer include claims of creditors. The claims of the creditors of the adult child could be satisfied through the assets of the parent if the parent makes outright transfers to the child, and matrimonial actions. For example, if the child to whom the assets are transferred is subsequently divorced, transfers assets may be subject to the claim of equitable distribution. While the law dictates that assets transferred from a parent to a child may not be subject to equitable distribution, practitioners in the field of family indicate judges often find ways to give additional assets other than the transfer assets to the other spouse. In addition, assets could be transferred could affect alimony support rights. And finally, White set up a special needs trust, bad habits. If the parent transfers assets to the child who is a gambler, drug addict, alcoholic, or spendthrift, the assets may be squandered and no longer available to the parent. For more information on protecting kids and spendthrift trusts, visit website njlaws.com, and for assistance by an attorney, contact Kenneth Vercammen's office in Edison, 732-572-0500.